LME3701, Section B, the Legal Research Proposal, the Learning Units. Learning Unit 1, Research Proposal. 1.1, Introduction. Your research proposal is a vital aspect of the research process. Your proposal is a written outline of your thinking on the research problem and shows the reader how you intend to prove your hypothesis. Let us pause for a moment and consider the nature of a research product in law. A good research product at undergraduate level has the following characteristics. First, it avers a certain knowledge claim relevant to a specific area of law and provides evidence to support and defend that claim. Keep in mind that defending a claim is not a one-sided pursuit. In order for your argument to be valid, it must examine all sides of the claim you make, not simply the arguments that defend your chosen position. Secondly, it demonstrates in-depth knowledge of the primary sources relevant to the chosen field of law. The primary sources are authoritarian in nature. Secondary sources are persuasive and must be used to show that experts in the field support your arguments. Think of primary sources as the foundations of a house. They provide the groundwork for you to build on and are the most important part of the structure. Secondary sources form the walls of the house and allow you to construct a pleasant environment in which to live. The roof of the structure is composed of your conclusions and recommendations. Without the foundations and walls, the roof has no support structure and would simply fall flat. Your research product cannot ignore the foundations or the walls of the building. The research proposal is the first chance you have to organize your research problem and to create a framework for later consultation. Consider it a roadmap. It keeps you focused on your topic and allows you to structure your research early on in the research process. A research proposal is a written plan of your research project or research design. It has two functions. Firstly, it can be understood as planning of any scientific research from the first to the last step. This plan should specify the phenomenon to be studied, the reasons for investigating that phenomenon, and how the investigation of that phenomenon will be carried out. In this sense, the research proposal is a program to guide the researcher in collecting, analyzing, and interpreting observed facts. The proposal should be well structured, concise, clear, and comprehensive. Secondly, it also relates to the testing of your research questions. In short, the research proposal is a plan in which you state how you intend to conduct your research. The proposal has the following characteristics. First, it's like a map. It guides you through your research. Secondly, it's like a picture. It gives you an overall view of the whole process and of the important actions you will need to take to complete your research. And lastly, it clarifies exactly what is expected of you. You will find the whole process of writing a research proposal confusing to begin with, as the terms used can be confusing and common phrases are used differently in different fields of research. For your convenience, we have reproduced in paraphrased form a table of generic questions and corresponding terminology from a book called Making the Researcher's Life Easier by Matthews and Taylor, in order to orientate you to terms used when writing research proposals and their corresponding synonyms. Then you can just study table 3 there on your own time. Then they just say, as you can see from the above, many of the key terms of a research proposal answer very basic questions in the line of when, what, where, and how. Different fields use different terms, but in essence they all remain more elegant terms for the basic when, what, where, and how questions. Below we have reproduced a paraphrase table from Matthews and Taylor to demonstrate aspects of research proposals in different fields of research. And then you can just study table 4 as well on your own time. Then they continue to say, The challenge with law is that it can fit into more than one of the above categories. For this reason, a research proposal in law often borrows parts from various fields, mainly the social sciences and philosophy. A research proposal in law at Unisa must contain the following elements. First, the title page. Secondly, a proposed title or working title. Third, introduction. Fourth, a problem statement. Fifth, a hypothesis deduced from the problem statement. Number 6, points of departure and assumptions. Number 7, conceptualization of central research themes. Number 8, proposed chapter layout. Number 9, a projected timescale. Number 10, a description of proposed research methodology. Number 11, preparatory study and research. And number 12, the conclusion. Additional requirements may be set by your supervisor. The extent of a proposal varies. In the case of a proposal for an LLB research report, it should not exceed 12 pages, excluding the title page, preliminary material, and bibliography. Study Unit 2, Preliminary Work. 2.1, Constructing a Research Journal. In Tutorial Letter 101, we have provided you with a set of legal research problems, which you will use to complete this module. In your fourth year, you will be required to draft a research report based on topics covering different areas of law, from the different departments in the College of Law. For now, we rely on the topics provided in Tutorial Letter 101 to advise you on completing this module. The first step in this learning unit requires you to read Tutorial Letter 101 and identify the research problem you are going to pursue. In other words, we have already identified the knowledge gap for you to concentrate on. You will formulate your research proposal using the guidelines contained in the remainder of this study guide. The first step after identifying the gap which you wish to research, which we have done for you, is to undertake a literature review and to organize your research. When you have decided on a topic for your research study, it is time to gain all and any knowledge you can on the subject. This is sometimes called a literature review or scholarship review. It consists of reading the existing knowledge in the field you are researching, and was referred to above as a collection of knowledge claims made by others, which constitutes the existing database of knowledge on a topic or field. Although you may feel overwhelmed by the amount of literature available, you will eventually begin to see a pattern in the available knowledge. At this point, we suggest you make use of a research journal, hard copy or electronic, to categorize knowledge claims. Divide your journal into the following categories. A. Legislation. B. Case law. C. Journal articles. D. Books. E. Electronic resources. And F. Miscellaneous sources. Under each heading, write down the citation for each source you read and make concise notes as to the content of that source. In some cases, such as this will be straightforward because you will only examine specific sections that state the law as it currently operates. Articles and cases may present more of a challenge because they frequently present more than one side of an argument. Make notes of all knowledge claims made in court cases and journal articles. This exercise will allow you to see the pattern of thoughts and views in the field as it currently exists. But it will also help you later when you construct your research proposal and bibliography. Your goal with a literature or scholarship review should be to investigate what information is available on your subject of choice and how other authors have investigated the topic. Some of the aspects you want to include in your research journal are: first, definitions of concepts. Secondly, different theories, questions, and available models in the area of your research. Third, data and empirical findings by other researchers. And lastly, how different courts interpret the law. Keep in mind the system of precedent. precedent. 2.2. Organizing your research. At this point, your research journal provides the method by which you will organize the information obtained from your literature review. There are a number of ways in which you may structure or organize the research journal. Above, it was suggested that you divide your journal into source types, but you may have another method. This is fine provided it presents knowledge logically. Some researchers are alphabetical hardcover school books, others Excel spreadsheets, and some the old index card system. It does not matter how you format your journal as long as it works as an information retrieval system that you understand. Keep the following guidelines in mind when constructing your research journal. First, organize your research material into primary and secondary sources. Remember to keep comprehensive citations for each source. Many a researcher has come to the end of a research project and then cannot locate the complete reference to a source they've used. And secondly, when you deal with case law, it is a good idea to summarize it in your research journal. Summarizing case law, specifically when the judgment is long and complicated, allows you to refine the salient points of the court's rationale. At the end of your literature or scholarship review, which is condensed and organized using the journal method, you can begin the process of writing the first draft of your research proposal. At this point, consider the following. First, who is the audience? Your audience in the academic setting is primarily your study leader or supervisor who expects a certain level of sophistication in both writing style and knowledge. Secondly, what does my audience need to know? Your supervisor is likely to be an expert in the field you are working in, and this may not require in-depth analysis of the basic concepts of your research topic. And thirdly, what arguments am I going to advance in favor of my knowledge claims? Here your research journal becomes central. You already have a list of sources for and against your knowledge claims, provided that you constructed a proper framework during the scholarship review phase. And lastly, what am I going to do with evidence that contradicts my knowledge claims? A good researcher never ignores evidence contrary to their knowledge claim, but rather analyzes the contrary knowledge and refutes it by way of further knowledge claims or evidence. Another way of dealing with contrary research finding is to show how they may be corrected if used in a specific context, but may be flawed when framed in another. Remember that research is an ethical field. Do not attack another researcher's character, but rather his evidence or knowledge claim. There is no need to be petty or derogatory about another researcher's work. The fun in research is the argument and counter-argument, just so long as it is conducted with respect and in a manner that acknowledges and respects the dignity of others. Always keep in mind that there are always different ways of looking at a problem. Once you have conducted a basic literature review, you will be more au fait with your research field of investigation. At this point, you have identified the knowledge gap, conducted an overview study of the available literature, and gained preparatory knowledge to set the field for your research proposal. You can now begin the process of drafting your research proposal. Learning Unit 3. Proposed or working title and introduction. 3.1. Proposed working title. The title of any research product must be a reflection of your research theme. The aim is to inform the reader what the study addresses without coming to any conclusion on your hypothesis. Once you have completed your scholarship review, you are in a position to determine an exact title. A well-formulated title carries weight in the knowledge database because it itemizes the knowledge you formulate. A well-formulated title should meet the following criteria. First, it should be brief yet informative. Your title is not a summary but an identifier. It places the reader in a position to determine whether the research is suitable for their needs or interests. Your title must not include excessive explanations. For example, consider the following titles: Legal representation of children before the South African courts with specific reference to rules of ethical practice and conduct. Although the above title appears suitable for research, it lacks in certain aspects. Firstly, it does not indicate what the author means by legal representation. Secondly, is the author referring to child offenders or children in private law? Thirdly, it does not identify the court structure that is relevant in the study. Fourthly, it is too wide. The second title: Competent legal representation of child offenders in the pre-trial and trial phases of the South African criminal justice process. This title is more suitable because it tells the reader exactly what the research is concentrating on. Okay, secondly, the title must be informative and tell the reader what area of law and what aspects of that area is addressed in the research. And lastly, it must be linguistically correct and the spelling must be impeccable. You should also avoid stating your title in the form of a question. Examine your title after writing it down and ask yourself whether it encapsulates your research content and whether there is any ambiguity in the wording. A good practice is to show the title to a colleague without telling him about your research topic. Ask your colleague to indicate what he thinks the title relates to and to explain the content they would expect to see in an article with the same title. If the answer does not reflect your intention, then consider rewording the proposed title. Remember that although we have provided you with a research topic in Tutorial Letter 101, you are required to frame your research title. Do not simply restate the problem posed as a title. Even though the working title appears first in your proposal, you may want to only finalize your title after you have written your proposal, as you will then have a better idea of the scope and limitations of your research. The next part of the research proposal should encompass your research introduction. 3.2 Research Introduction. Your introduction should familiarize the reader with the context and scope of the topic. It should also provide information to contextualize the topic and the problem by identifying the general importance and present understanding in the field. In brief, an introduction should give a short overview of the problem, issues or topic to be researched, and of the reasons why it is an important problem to study. In some cases, the introduction concludes a historical background to the problem. In general, your introduction must, first, establish the field of the topic. Secondly, identify a particular focus of the topic within a specific field. And lastly, identify the more specific parameters of interest. Below you will find generic excerpts taken from previous research projects. Topic 1. This research investigates the field of South African public law at a macro level and constitutional criminal procedure at a micro level. The research focuses specifically on the constitutional right to legal representation within the framework of the Criminal Procedure Act 51 of 1977. The research focuses on the meaning and interpretation of the right to counsel within the parameters of equality of arms. Topic 2. This research investigates the field of South African public law at a macro level and a constitutional criminal procedure at a micro level. The research focuses specifically on the constitutional right to open justice within the framework of the Constitution 1996 and Criminal Procedure Act 51 of 1977. The research focuses on the impact of social media on the fair trial rights of the adult accused. Topic number 3. This research investigates the field of South African public law at a macro level and constitutional criminal procedure at a micro level. The research focuses specifically on constitutional interpretation and development within the framework of the Criminal Procedure Act 51 of 1977. The research focuses on the meaning of and interpretation of customary law within the parameters of the trial process for adult accused. The focus of this investigation is limited to the trial and sentencing phases of the criminal process, and this disregards pre-trial process and post-trial remedies. Note that the above examples tell the reader what general area of law you are researching, what specific part of the area you have isolated, and finally, what aspects of the area you are investigating. They are by no means complete and can be further elucidated depending on your particular research focus. You can now apply the same principles to the problem you are researching as contained in Tutorial Letter 101. Thus far, you have told the reader what the problem is and where it is found in law. Next, you need to develop the problem statement to assist the reader in understanding how you will go about solving the problem you have identified. Learning Unit 4. Problem Statement. Research is intended to answer questions in a scientific manner. Before research commences, therefore, the issue or problem that will be investigated must be considered, clearly delimited and explained. Before a compact formulation of the problem statement can be achieved, an explanatory exposition must be given. Firstly, a case must be made that the issue is indeed a scientific problem, and secondly, that it is worth the research and calls for resolution. The formulation of the problem statement must convince the reader that the project should be undertaken. In formulating the problem, it must be kept in mind that it must serve as a guideline for the research throughout the entire project. This means that the following must be kept in mind. First, the extent of the question or problem must be appropriate for the proposed project, because the problem statement determines the parameters within which the project will be carried out. The researcher should, therefore, consider what the end result must be. In other words, do not undertake a study for an LLB which is more appropriate for an LLD study. Secondly, the problem must be solvable. Although the researcher cannot be expected at the time of formulating the problem statement to know what the conclusions are going to be, he or she must know enough to be satisfied that it is a viable project. You should, however, keep in mind that it is sometimes enough to simply point out a problem that no one else has identified. And lastly, it must be understandable. The problem statement must be outlined with sufficient clarity so that, firstly, the researcher is never in doubt as to the type of research that is being undertaken, and secondly, that the reader of the problem statement does not have any doubts as to the direction of the project will take. At the end of the exposition of the problem statement, the essence thereof must be set out in a single sentence, frequently in the form of a question. This, however, largely depends on your research topic, and it will not always be possible to put the problem to a reader in one sentence or question. Below you will find two examples of very brief problem statements. They are not real problem statements, but are intended to show some of the typical mistakes researchers make. Okay, the first example. I awoke to the sound of hungry babies crying. I felt helpless because there was nothing to feed them. That is why I decided to write about the funding problems of orphanages. People should be ashamed of themselves for not caring. It is all the government's fault for wasting money on trains and so on. I will be telling you the truth about this. The comment to that is, the problem is that this statement is emotional and unscientific. While it is certainly sad that orphanages are not funded appropriately, that is not the point of a problem statement. The researcher must indicate why this is a legal and scientific problem and how the research can help to solve the problem. An appeal to emotion is not enough. Finally, you should avoid using the first person. I, me, us, or our in scientific writing. Okay, now for the second example. South African law is basically Roman Dutch law. That is why the writings of Roman and Dutch authors are important. South African law developed from Roman law and can therefore be said to have a 2000-year history. In this article, I will look at timeshare contracts from early antiquity to today. The comment to that is, you can easily see what the problem is here. There is no connection between the first two sentences and the last one. In addition, no problem is indicated, so the reader does not know what the problem is with timeshare contracts and what that has to do with Roman law, or why he should care. A statement of the problem, sometimes called the statement of purpose, is the most important part of your proposal. It should therefore be written with such clarity and in such logical and sequential fashion that it may stand alone on its own merits. If so done, it should indicate not only the problem for which you seek a solution or answer, but also the steps whereby you plan to find that solution. The statement must flow from the introduction and should read logically to your research goals and research questions. Marie states, in a well-formulated statement of purpose, words like assess, explore, and compare are used to state the researcher's intention explicitly and indicate how the research will be done. 4.1.1 Problem Statement Examples. Here are some basic examples based on the topics from previous research proposals in continuation of the topics introduced in previous learning units. Topic 1. The purpose of this research is to critically analyze the right to legal representation in criminal litigation and to investigate the potential effect of competency, or lack thereof, on equality of arms considerations in South African criminal procedure. Topic 2. The purpose of this research is to evaluate the use of social media as a reflection of open justice and to gauge its impact on the fair trial rights of the accused in South African criminal procedure. And then topic number 3, the purpose of this research is to evaluate the integration of customary law in South African criminal procedure and to evaluate the potential for its development as a constitutional consideration of interpretation. The major question or statement should be included with a possible list of secondary questions following as appropriate. Each of the statements above can be divided into sub-questions, statements, or hypotheses. For example, topic 1. This research will include aspects that incorporate the following. First, what is the practical application of the right to legal representation in South African criminal procedure? Secondly, does the right to legal representation make reference to the efficacy or competence of legal counsel? Third, what is the meaning of equality of arms, and how are competency considerations assumed therein? And lastly, what is the effect of inequality of arms or incompetency of counsel on an accused? Okay, now topic 2. This research will include aspects that incorporate the following. First, where does open justice find application in the Constitution, and how is it interpreted in the criminal process? How has the use of social media affected how has the use of social media affected the right to an open public trial for adult offenders? And lastly, does the use of social media have advantages or disadvantages for the fair trial right of the accused, and how can these be developed or mitigated within South African criminal procedure? And then for topic number 3, this research will include aspects that incorporate the following. First, how does the Constitution incorporate the development of customary law? Secondly, what is the impact of customary law on constitutional interpretation? Third, what values underlie the incorporation of customary law in South African criminal law and procedure? Fourth, where do customary values and practices find application in the current criminal process? And lastly, Where could customary values and practices find further application in the existing criminal process? This section is an extended discussion of the problem, often with some literature noted in the footnotes to show the reader that the research problem is valid and necessary to solve. You can now apply the principles above to develop the problem statement for the research topic contained in Tutorial Letter 101, Assignment 2 for LME3701, before moving on to the next step in the research proposal, viz. The hypothesis. Learning Unit 5. The research aim or hypothesis. What is a hypothesis? A hypothesis is an unproven statement, the truth of which is provisionally assumed, but with a view to subjecting it to scientific analysis in order to determine its truth. While a hypothesis should not be confused with a conclusion or a research result, neither is it merely a wild guess or what the Americans would call a hunch. A hypothesis is formed on the strength of prior knowledge and rational anticipation of the answers expected to be found to the research problem. The intention is not to prove the truth of the hypothesis at all costs, but to test it to the utmost with scientific honesty before it can be included in a theory or be accepted or rejected as a conclusion. The development of hypotheses, therefore, also requires thorough consideration and precise formulation. In law, we do not always find an hypothesis in a research proposal. It is more likely that you can easily fit what you intend to find under a research aim. This could especially be the case if you are embarking on a historical research project or a comparative research project in order to establish how we reached a certain point in law and or how a certain jurisdiction approached to a specific legal issue. It could be challenging to formulate a hypothesis here, as the research does not really serve to prove something, but rather explores a certain state of affairs or phenomena. In essence, your research problem or statement identifies what the problem is. The hypothesis tells the reader what you consider to be the solution. At the beginning of your research, you cannot prove your hypothesis. That is the point of researching it. In some cases, specifically with descriptive research, the hypothesis and the research problem are synonymous. A hypothesis can be a single solution or a series of solutions, hypotheses, which you predict will solve the issue identified in your research problem or statement. At this point, you should have a general idea of your research area, research problem or statement, and the hypothesis, hypotheses, or research aim. Once you have isolated your research problem or statement and hypotheses or research aim, you must determine if your research problem or statement is empirical or non-empirical in nature, because this orientates the reader to your method of research and research design. Your research method and design tell the reader how you intend to prove your hypothesis or achieve your aim or goal, which are based on your research or problem statement. Your research statement will typically be empirical or non-empirical in nature. More on research methods in Learning Unit 10. Learning Unit 6. Points of departure and assumptions. The point of departure refers to two things. In the first place, it refers to the basic theory behind a research project. It is important to consciously formulate one's point of departure because it provides a test of consistency throughout the module of research and gives direction to the making of basic scientific, especially theoretical, choices. If, for example, you study the position of women after divorce, you could do so purely from a patrimonial point of departure, that is, from the private law theoretical perspective, or from a procedural point of departure, that is, from the point of view of the law of civil procedure, or from a feminist viewpoint, that is, a study of feminist critique of divorce law. You can see that in all these cases, the content and conclusions of the project will differ widely, even if they deal with the same subject. Therefore, the same subject from different points of departure will lead to different research projects. Your point of departure is basically the angle that you are taking to look at the research problem. It is from a constitutional law perspective or administrative law perspective, etc. In the second place, the point of departure refers to the method of research that you choose. You may choose a historical method, a comparative method, for instance. The methods were discussed in a previous section, but you must state the methods you choose explicitly in this section of the research proposal. Almost inevitably, though, legal research will largely be based on a literature study. The nature of the material, that is, legislation, decided cases, journal material, monographs, and textbooks, electronic sources, material of other disciplines, sources in other languages, and so on, that is expected to be of greater significance for the research may also be indicated here. The proposed method must be suitable for the resolution of the problem statement. In order to limit your study and to keep it manageable, it is frequently necessary to make certain assumptions. Usually, the making of an assumption entails that a certain state of affairs is taken as a given. For example, it is not necessary to prove that South Africa is a constitutional democracy. You can take it as proven. Assumptions are there so that you do not need to prove anything, so that you can exclude some things from your study and to make use of well-known previous research. In other words, this is where you say what you will be doing, but more importantly, what you will not be doing. This is important to forestall any possible criticism about things your examiners might think should be in your dissertation. If you say you will not be doing certain things, they cannot criticize you if you do not do them.